So here we have now Section 11, and Section 11 is all about exceptions to privileges or yung privilege of confidentiality of information. Okay, so here, there is no privilege against disclosure under Section 9 if mediation communication is done through the following manner. So, una na dyan. Number 1 is in an agreement evidenced by a record authenticated by all parties to the agreement. So, take note of that, evidenced by a record authenticated. So, meaning it is through document. Okay, so paano nila ma-authenticate yan? Through their signatures, of course. So, dapat pirmado nila yan. Okay, para masabi na tunay yung dokumento na yan na yun, hahayaan nila na yung lahat ng informations na bring out or may brought out during the process of mediation will be disclosed or can be disclosed to any future proceedings, okay, or in public. So, yan po yung sinasabi ng number 1, okay? And then, number 2, it says here, available to the public or that is made during a session of mediation which is open, okay? Paano kung yung mediation, okay, yung kinandak nilang mediation process is open to the public. Doon, yung parang sa korte, wherein it is open to the public. So, yun, kapag kinandak nila in public, okay, or open to the public yung mediation, then that could be or masasabi natin na lahat ng informations na nag-gather during that process of mediation will be treated or will not be treated as confidential. So, okay lang na mai-disclose yun sa kahit saan. Okay? So, yan yung tinutukoy dyan sa number 2. Next, here we have 3 and 4. So, 3 and 4, it has something to do with crimes. O, paano naman kapag yung mga informations na dinadivulge na during the process of mediation? Just like threat na papatayin kita. Okay? Or sabihin natin, sisirain ko yung properties mo kapag ganito, hindi mo pinagbigyan yung gusto ko, mga ganong bagay. So, that could lead to criminality. So, yung mga ganong informations or mga details na nailalabas during the process of mediation, they are considered or they will not be considered as confidential. So, pwede po natin yan ma-divulge, okay, or ma-disclose on public, okay? So, parehas lang po yung sinasabi niya dyan sa number 3 and 4. It is about crimes, okay? So, if it could leads to crimes, yung mga informations na yun, then that could not be treated as confidential. Dapat yun ay malaman kasi yun nga, isa sa concern natin is crime prevention, di ba? Okay, so hindi dapat tinatago yung mga informations na yun. Dapat yun dinidisclose talaga. Now we have here number 5. Okay, so what if the communication naman it's sought or offered to prove or disprove abuses or exploitations or abandonments? So paano naman kapag ganun yung magiging effect ng communications or ng informations na yun? So can it be disclosed? Okay, pwede ba nating i-publicize yan? Okay, so simply yes. Okay, kasi sabi nga natin dyan, those acts could be or could lead to criminality, di ba? Diyan, abuses. It can cause, crimes. It can cause crimes. Okay? Abandonment, exploitations, those could be a form or an act of criminality. So, those communications or informations should or necessary to be disclosed also. Okay? Tanong, paano kaya kapag bata yung involved? What if child yung involved? Kasi sabi dyan, but this exception does not apply. Okay, so yun, simply, kung bata yung involved, lahat ng informations, ng communications that will be taken or that will be brought out during the mediation process shall be still taken or treated as confidential. Okay? So yun yung exception dyan. Yun yung pagkakaiba dyan sa number 5. Okay? So, tandaan ninyo, kapag bata yan, dapat lahat ng informations ng communications is treated to be confidential. Bakit kaya? Kasi proprotektahan natin yung image ng bata. So, anong mangyayari dun sa bata? Kunwari, kapag yun, na-divulge yung mga informations na yun, yung issue dun sa kanyang parents, sa paghihiwalay ng kanyang mga parents, sabihin natin. Okay, yung mga away ng parents niya, okay? So, na-disclose yung mga yun, meron yung epekto dun sa paglaki ng bata, di ba? Usually, pag chichismisan yan ng mga kapitbahay niya, ng mga nakakilala or nakarinig ng mga informations na yun, okay, na-disclose. So, yun, magkakaroon ngayon ng psychological effect doon sa bata. So, parang magiging hindi na siya, dahil sa pinagchichismisan siya, dahil sa kinamumuhian siya, so hindi na magiging normal yung pakikipag-socialize niya doon sa mga tao. Okay, so yun yung purpose niyan, kaya hindi po pwedeng i-divulge or i-disclose natin yung mga informations na involve yung bata. Okay, so number 6 naman, paano kaya kapag yung information or communication na i-divulge natin, i-disclose natin can prove misconduct or malpractice of a mediator. Okay? So, paano kapag yung mga informations na yun na i-divulge natin, pwedeng makapagturo, okay, makapagsabi, or can be serve as evidence na yung taong yun or yung mediator na yun is hindi siya patas, okay, dun sa pagdi-decide niya dun sa mga cases or dun sa case na hinawakan niya. So yun, that is also still exceptions to the privilege of confidential information. Kasi yan nga ay isang parang illegal din yan. So dapat lang na i-divulge natin, i-disclose natin yung communication na yun. Kasi yun nga, hindi po pwede. Sabi natin, a mediator should be impartial. So, wala dapat siyang pinapanigan. So, yan, in order for us na to tolerate those kind of acts, nararapat lang na i-disclose natin yung mga informations na yun or mga communications na yun during the mediation process para mabigyan ng hustisya or para magtanda yung taong yan, yung mediator na yan. Okay, so hindi na ginagawa ng tama yung pagiging mediator niya. Okay, so that is number 6. Proceed naman tayo dito sa number 7. So, sabi natin kanina sa number 6, it is also on the part of the mediator, di ba? Malpractices of the mediator. Now, on number 7, it is also on the misconduct or malpractices of the other parties. Sino yung mga to? It's either yung claimant or the respondent. Okay? Kung hindi man yung non-party participant, as mentioned there, sino yung non-party participant? Sabi natin ulit dyan, yung mga stenographers or mga secretaries na na-hire during the conduct of mediation. Or nandito rin yung representative of the party. Sino yung tinutukoy natin na representative of the party? Siyempre, yung mga lawyers or mga attorneys na hinire ng bawat parties na ito. Okay, so yung mga information that could or mga communications that was brought out during the conduct of mediation na pwedeng mag-prove or mag-claim ng misconduct or malpractices or somewhat biasness ng mga to, ng mga participants na ito, okay, misconducts or malpractices ng mga parties na ito can be, the communications can be disclosed. Okay, so that is still under section 11. They are exceptions to the privilege of confidential information. So hindi po yun maititreat as confidential information. They could be considered or they could be disclosed whether or whenever it is necessary. So we have now here in the next slide, still on section 11, the exceptions to privilege, we have here paragraph B. So during the previous slides, okay, it talks about the disclosure, or in paragraph A, it talks about disclosure of those informations or communications. Here in letter B, it talks about evidences. So those communications, mediation communications that was brought out can be used as evidences only. Sabi dyan, on number 1, if it is offered in a court proceeding involving a crime or felony. Okay, so if involves a crime, it is necessary for us to brought it out and use as an evidence. Okay, so that is what is being said here in this part. So in number 2, we have here now, it can be also used in a proceeding to prove a claim or defense that under the law is sufficient to reform or avoid liability. So it talks about the contracts. Okay, so yun naman, kung nandun naman sa kontrata, then that is to be followed. Okay, so that is what is being said here in this slide. In this slide, we have paragraph C. So it says here, a mediator may not be compelled, as we have said a while ago, it was already mentioned a while ago, that mediators cannot be compelled to testify, okay, or to brought out communication, disclose communication that was brought out during the conduct of mediation. So, yan lang naman po yung dito sa letter C. Now, we have here letter D. So, it says here, if a mediation communication is not privileged under the exception in subsection A or B, or yung mga na-mention natin kanina, hindi nabibilang doon. And then, sabi dyan, only the portion of the communication necessary for the application of the exception for non-disclosure may be admitted. Okay, so take note of the word necessary. Okay, so it talks about practicality of the law or practical application of the law. Okay, so kung yun, kinakailangan naman, okay, or it is necessary na malaman natin or ma-disclose, then it should be or it can be admitted. Okay, it can be admitted as evidence and as evidence in court. Okay, so yan yung minimension dyan. So, yan, it depends upon the discretion of the court also to decide. It's either na hindi man na-mention dito sa exceptions to privilege, pero yun naman kung kinakailangan, okay, or necessary and upon the discretion of the court, then it could be admitted as evidence. Okay, so that is what is being said under section D. And that is also all about section 11. Let us proceed on section 12. So, section 12 is all about prohibited mediator reports. Okay, so kailan lang pwedeng tanong dito, kailan pwedeng submit ng reports. Okay, mag-submit ng report, assessment, evaluation, recommendation, finding, or other communication regarding the mediation process ang isang mediator. So, kailan siya pwedeng mag-submit ng report? Saan siya magsasubmit? Sa korte, okay? So, dun sa court or any other agencies that has a ruling over the dispute. Okay, so, ito lang yung may instances. Sabi dyan, where the mediation occurred and has terminated. Okay, so kung tapos na yung mediation proceedings, then that is the time he can make or he can submit a report to the court or any other agency that is having a control or ruling over that dispute, such as Office of the Mediation Center. Okay, so that is only one. And then as permitted to be disclosed under section 13 of this chapter. So yung pag-uusapan natin later on is yung section 13. So tignan nga natin. So under section 13, we have here paragraph A. Okay, so here it speaks of on the part of the mediation. So sabi dito, before accepting a mediation, an individual who is requested to serve as a mediator, ito muna yung dapat niyang gawin or i-find out. Okay, so sabi dyan, number 1, make an inquiry that is reasonable under circumstances to determine or determinate whether there are any known facts that a reasonable individual would consider likely to affect the impartiality of the mediator. Okay, so dito, kailangan niya munang i-find out, tignan yung background ng mga parties na yun na lumalapit sa kanya na nagre-request. Okay? Tignan niya, baka meron pala siyang connection. Okay? So, anong mangyayari kasi pag meron pala siyang connection? Sabihin natin, ka-business partner pala niya. Okay? Or isa yung taong yun sa mga mga kakilala niya, ka-close niya, or kasosyo niya sa business. Okay? So, yun, it could lead or it could affect his decision making kapag meron yun, or kapag nag-undergo na sila ng mediation process, okay, or meron ng result na ibibigay, okay, so magiging bias siya. So in order to avoid that, kailangan niyang ito yung gawin. Number 2, na-find out niya, hindi pala pwede kasi ka-business partner ko yung isang party na nagre-request na mag-act ako as mediator. Okay? So yun, that's the time ang gagawin niya here in number 2, disclosure to the mediation parties any such fact known or learned as soon as possible is practical before accepting the mediation. So yun, kinakailangan sabihin niya, i-report niya, and then sabihin niya, hindi ako pwede as mediator. So still under section 13, we have here paragraph B. So as we have mentioned a while ago, if there is an existence, doon sa paragraph A, there's an existence, okay, of a relationship of that requesting party, okay, for you to act as a mediator, then you should disclose it, or pwede mong i-deny yung request, okay, to act as a mediator, okay. So it is on continuation of letter B. So sabi dyan, if a mediation learns any fact described in paragraph A, number 1, okay, it says here, disclose it as soon as practicable. Okay, so kailangan yun sabihin mo na hindi pwede kasi meron tayong yun pala, ka-business partner pala kita. I have a personal attachment sa'yo. So, it could lead to biasness if ever I will be your mediator. Okay? So, yun. And then, meron din dito, sabi dyan, at the request of the mediation party, an individual who is requested to serve as mediator shall disclose his or her qualifications. Okay? So, wala naman nabanggit dito as special qualifications. Okay? Walang nabanggit dito na qualifications ang mediator. Okay? So long as siya yung pinipili ng both parties. Okay? Kasi sabi nga natin on the process of mediation, voluntary in choosing of the parties kung sino yung mag-act as mediator nila. Okay? And then yun, sabi dyan, this act does not require that a mediator shall have a special qualifications by background. Except yung dispute na isosolve niya involve ang family problem. Okay, sabihin natin family relations, okay, so, or divorce, sabihin natin divorce, pagdi-divorce ng mag-asawa. Okay, so 'di ba sa mga lawyers kasi natin merong mga kanya-kanyang specialization din 'yan, okay? Lawyers or mga may background sa law, merong mga specialization yan. Meron yung specialized sa criminal law. So, ibig sabihin, magaling siya sa criminal law. So, dun siya nagfo-focus. Okay, and then meron din yung specialized sa civil law. Okay, so yun, meron siya expert dun sa civil law. Meron din yung iba expert sa or specialized sa family relations. Okay, or yung mga law involve ang family problems or family disputes. So, yun, kinakailangan na yung mediator na kukunin natin or i-request natin should be only specialized on family relations. Kasi, family problem nga yung disputes natin. Okay? So, yun lamang yung gustong i-point out ng paragraph B sa atin dito. Okay? So, we have here now section 14, and section 14 speaks of the participation in mediation. So, dyan, sabi nga natin, pwedeng mag-hire ng sari-sariling attorney or sari-sariling lawyer or sino man, kahit sinong tao na gusto nilang kunin to assist them in the process of mediation ng both parties. Okay? So, pwede silang kumuha. Sabi dyan, lawyer or any other person. So, not necessary a lawyer. Or pwede namang merong background lang sa law, pwede nilang kunin as a representative nila in the conduct of mediation. Okay? Pero, paano kaya kapag sabihin niya, Your Honor, or kung ano man yung tawag nila. Okay? Yun, sasabihin niya, hindi po ako kukuha na ng aking representative or tao na mag-a-assist sa akin on the process of mediation. So, yun, paano kung sasabihin niya yun or hindi na niya daw kailangan ng attorney? Okay, yung isang party, ayaw ko na, hindi ko na kailangan ng isang lawyer para mag-assist sa akin. So, yun, kailangan niya i-waive ito through writing. Okay, so it should be made in writing. Hindi po nasabi dyan na orally. Okay, so it should be made in writing po. Naka-mention dyan sa section 14. Paano naman kaya kalagitnaan ng kalagitnaan ng mediation process, naisip niya, nako, kailangan ko pala ng lawyer. Okay, so pwede ba niyang i-take back yung waiver niya? Okay, yung pag-waive niya dun sa right niya to or privilege niya to hire or to take an attorney na mag-a-assist sa kanya. Pwede ba niyang sabihin, mag-hire pala ako ng attorney. Kailangan ko pala. Okay, pwede ba niyang gawin 'yon? Okay, so as we have mentioned here, as mentioned here in section 14, sabi dyan, a waiver of participation or legal representation may be rescinded at any time. Okay, so rescinded meaning it can be taken back, okay, or removed. Okay, so pwede niyang i-cancel yung pag-waive niya dun sa privilege or right niya na yun. So pwede siyang kumuha na ng kanyang attorney or representative. Okay, so yan po yung tinutukoy dyan sa section 14 or in other words, participation in mediation.